Effective April 1st, all foods currently at 5% VAT will be VAT-free. Zero VAT on those food items.
Well, good morning, everyone, and welcome to the Office of the Prime Minister. We have called this special press briefing this morning to announce what we consider a landmark decision in the interest of Grand Bahama. This is particularly to do with the Grand Bahama Port Authority and the arbitration that it's been engaged in with the government of the Bahamas. We are happy to be joined this morning by Attorney General, the Honorable Ryan Pinder, who will give a statement on the results of the arbitration, which has been going on for close to 2 years now. We're also happy to be joined by Minister with responsibility for Grand Bahama, the Honorable Ginger Moxie, and Minister of Health and Wellness, a former Grand Bahama Minister for Grand Bahama, the Honorable Dr. Michael Darville. So without further ado, I welcome with a statement Attorney General, the Honorable Brian Pinder. Mr. Pinder.
Thank you very much. Good morning. I want to thank everybody for joining us today. As many of you would know by now, there has been a partial award by the Arbitration Tribunal in the government's case against the Grand Bahama Port Authority and the Port Authority's counterclaims against the government. Just so the public is aware, as prescribed in law, arbitration proceedings are confidential by definition, and awards are released according to the rules when both parties mutually agree that it's in the public interest to release the award, and then you seek authority from the tribunal to release the award. We had made that request yesterday. This morning, the tribunal responded and issued their no objection to us releasing the entirety of the award. You would also note that the Grand Bahama Port Authority released a statement this morning. We would argue that statement is misguided, misleading, and does not portray the true intention of what the award ruled on. That is why they would have only released the last page of the award. The award is 139 pages, and you can appreciate it contains much more than was on the last page. The key outcome of the award is this is good news for the people of Grand Bahama, and good news for all Bahamian taxpayers. The tribunal confirmed that the Grand Bahama Port Authority has an ongoing contractual obligation to make annual payments to the government for the benefit of Bahamian taxpayers for the remainder of the term of the Hawksbill Creek Agreement until 2054. The amount of the payments will be determined through a contractual review mechanism. The government sought reimbursement for costs associated with the administration of Freeport under a clause in the Hawksbill Creek Agreement. The tribunal ruled that the relevant clause that we were proceeding under had been replaced by a clause in a 1994 agreement between the parties. The amounts to be paid will be worked out in new proceedings. The Port Authority made 8 separate counterclaims against the government, and the tribunal rejected 7 of them. This outcome is a historic one that we believe will benefit the Bahamian people greatly in the years to come. On May 3rd, 2024, the government filed a notice of arbitration seeking an award in relation to its claim for reimbursement of costs incurred by the government in relation to the administration of Freeport. That request and that notice of arbitration was made pursuant to Clause 15D of the Hawksbill Creek Agreement. On the 3rd of June, 2024, the Grand Bahama Port Authority filed a response to the notice of arbitration, in which it made clear that it intended to defend the claim on a number of grounds. The Grand Bahama Port Authority also gave notice that it intended to, and I quote, assert counterclaims for substantial damages and other relief in respect of what they regarded as multiple breaches on the part of the government of their duties owed to the GBPA by virtue of the express terms of the Hawksbill Creek Agreement and the implied terms of that agreement. On February 26, on Friday, the Arbitration Tribunal issued a partial award. The government has succeeded in establishing a liability by the GBPA to pay money annually to the taxpayer for the remainder of the term of the Hawksbill Creek Agreement. Allow me to provide a summary of the conclusions of the Arbitration Tribunal for your benefit. The tribunal held that Clause 15D of the Hawksbill Creek Agreement, that's the clause that the government was coming under, could not be invoked, since the clause had been replaced by a provision of an agreement between the parties in 1994. Remember, 1994 is when the F&M administration extended the tax concessions to the Hawksbill Creek Agreement for a further period of time. Under that provision, this is the provision in 1994 agreed to by the F&M government, the Grand Bahama Port Authority committed to pay $500,000 a year for 5 years. So that would have been between 1995 and 2000. and that the payments due to the government would then be subject to a review between the parties. The tribunal held that this contractual review mechanism remains operable and it remains enforceable, notwithstanding that it hasn't been enforced for many years. The tribunal held that is, and I quote, self-evident that the government can invoke the review for future years. It's very clear. Confirming that it remains fully enforceable and rejecting any suggestion that the review provisions had now become inoperable. The application of the review provision in relation to costs incurred by the government in past years, so pre our demand, which our demand was in 2023, so pre our demand, that is unresolved, but that is still a live issue. So historical amounts that may be due to the government is still a live issue. The tribunal stated that it would be able and prepared to determine this issue, to determine what is owed historically, if asked to do so by the parties. And the government will request the tribunal to do so. With respect to the quantum of the damages, it's of note that the tribunal has not determined the quantum of the sums due to the government from the GBPA. Again, this will be subject of the next phase of the arbitration. This is only a partial award. Let me speak a little bit about the GBPA's counterclaims in this arbitration, because they are substantial and they are very material to the governance of the Bahamas and particularly the governance of Freeport. The GBPA's counterclaim against the government was for substantial damages for wrongfully interfering in the administration of Freeport. This is a complaint which the GBPA has made repeatedly against the government for many, many years, and one which the government has always rejected. The GBPA now brought its complaints by way of a counterclaim in this arbitration, in which it originally claimed a sum of $1 billion, $1 billion in damages against the government. That was the GBPA's claim. GBPA's case that it has the sole right to administer Freeport and to deal with licensing, to deal with immigration matters, customs matters, the utilities and utility regulation, land purchases, development, environmental approvals, all of these were claimed by the GBPA as their exclusive right in Freeport, and every single one of them was rejected by the tribunal. The tribunal also rejected a complaint by the GBPA that the government had wrongly diverted investment projects from Freeport to other areas of Grand Bahama. That was a claim within the arbitration proceedings. Again, a claim by the GBPA rejected. The tribunal expressly held that the government's caution about the Weller-Pegasus development cannot be criticized, meaning the government had a right and was well grounded in its approach to the caution between the parties on that particular development, and that the government was entitled to prefer investment projects for other areas of Grand Bahama outside of Freeport if that was in the best policy decision of the government of the Bahamas. As a result, the tribunal rejected the entirety of the GBPA's substantial damages claim. Remember, the original claim was in excess of $1 billion, save for one minor issue relating to the failure by successive governments to give timely consideration to the approval and promulgation of 3 sets of environmental bylaws. So the only determination against the government of the Bahamas in this arbitration was since 2006, that's 20 years now, 2006, the government did not timely consider a request for amendments to environmental bylaws in Freeport. On this point, the tribunal said that it could not immediately see a basis for assessing damages to which the GBPA is entitled. I note the GBPA said today they're going to pursue damages. Well, the tribunal said they even questioned whether there could be any damages related to that breach. Given the magnitude of the counterclaim and the various complaints made by the GBPA, and the importance to the public of the government prevailing on these matters, I want to address them specifically so you get an idea of what the GBPA was suing the government about and what we prevailed on with respect to the governance of Freeport. And it's very important for the licensees. It's very important for the residents of Freeport. The GBPA wanted a declaration that the government was not entitled to require government approval for issuing of GBP licenses to non-Bahamian persons. In other words, they did not think that the government had a say in who can do business from another country in the port area. The tribunal ruled that the government was entitled to require this approval, not least because the parties had come to an agreement as long back as 1968. And all license applications made to the GBPA would be referred to the government. And they would not be granted if the government objected. The tribunal noted that the GBPA and the government had applied this agreement without question for over half a century. They ruled in favor of the government. The GBPA also wanted a declaration that the government was not entitled to regulate immigration in the port area. Again, the tribunal rejected the GBPA's case on this issue outright, holding that it was lawful for the government to legislate matters related to immigration and apply that legislation within the port area. The GBPA also wanted a declaration that the government was not entitled, listen to this, to operate a customs regulatory regime within the port area. They said we were not entitled to regulate what comes into our country through the port area. That was one of their counterclaims. The tribunal also rejected the GBPA's case on this outright, holding that the government was entitled to legislate these matters. And moreover, the parties had agreed in 1968 that the customs controls within the port area were to be standardized and coordinated across the entire country. Again, the tribunal rejected this claim. The GBPA wanted a declaration that it was the sole regulator of the construction, operation, and regulation of electricity and other utilities in the port area. However, the tribunal held that the government has a right to introduce legislation to apply to the construction, operation, and regulation of utilities in the port area and rejected the counterclaim by the GBPA. In fact, there's an ongoing case in our courts specifically on this issue, of which the power company is challenging the right of IRCA to regulate them. This arbitration makes it clear. IRCA has the authority in law to regulate utilities in Freeport. That case will be dismissed. The GBPA wanted a declaration that the government was not entitled to require non-Bahamians to register with the Foreign Investments Board in order to acquire real property in the port area. As we know, when a foreign person buys land in the Bahamas, they have to register that transaction with the Foreign Investments Board. The GBPA said, but not in Bahamas, not in Freeport. That tribunal, again, rejected this outright. They ruled that the government was entitled to do so. And it did by the introduction of the implementation of the Immovable Property Act of '81 or the International Persons Landholding Act of '93. The government has the authority to legislate throughout the entire Commonwealth of the Bahamas. The GBPA wanted a declaration that the government was not entitled to operate an environmental approval regulatory regime for developments in the port area. That DEP in our Environmental Planning and Protection Act did not apply. That was their claim against the government. Again, the tribunal rejected the GBPA's case, noting that as long ago as 1968, the parties had agreed that the Port Authority would consult fully with designated ministries or agencies in relation to the approval of proposals to schedule particular areas of land for particular types of development, and that it would give effect to any recommendations made by a ministry or agency in granting or withholding permits or approvals for any such development. This is a big one, because now this even broadens the scope of the government's authority in Freeport. The Planning and Subdivision Act, for example, is clearly now applicable to Freeport. So this is much broader, and the government has a legislative authority to regulate land development in Freeport. Finally, the GBPA wanted a declaration that the government had wrongly failed to take necessary steps to promulgate environmental bylaws for the port area, which were first proposed back in December of 2006. That's 4 government administrations ago. The tribunal concluded that the government was indeed in breach of its obligations to give reasonable and timely consideration to the proposed bylaws. However, as previously mentioned, the tribunal did not immediately see a basis for assessing damages, if any, that the GBPA would be entitled to, and I would put it to you that those damages are nominal, if anything. The importance of these findings in favor of the government cannot be understated. The GBPA's attempt to exclude the government from any involvement in the administration of Freeport would have a significant governance impact on Freeport, and its attempt to secure huge amounts of taxpayer money for itself, over $1 billion in their first claim, by way of damages on this basis would have had significant fiscal implications for the country. The partial award affirms the administration of the port area is not exclusively vested in the GBPA. At most, the GBPA retains specific contractual and administrative responsibilities. But these operate alongside and subject to the government's continuing power and the cession of approval of licensing, immigration, customs, and other matters to the government, as agreed by the GBPA as long ago as 1968. And that will remain the case, because of this partial award, throughout the life of the Hawkesbill Creek Agreement. Clarity in law has been given that the government has regulatory and legislative authority over matters in the port area. So what are our next steps? What are the next steps of this process? That's a fair question. The government will now work to have the remaining issues resolved as quickly as possible. Remember, this is a partial award. In practical terms, the annual review process can commence immediately in respect to future years. So from 2023, when we first invoiced the Port Authority, prospectively, this review process can occur now. Recovery for earlier years remains subject to further determination and directions from the tribunal, which the tribunal has indicated that is ready and willing to undertake as soon as possible, and we will ask them to do so. The government's focus will therefore be on progressing the outstanding issues to secure payment from the GBPA for the benefit of the taxpayer. As you would know, this has been a very significant arbitration for licensees of Freeport and for the government and the people of the Bahamas. The arbitration tribunal has brought clarity to long-standing disagreements between the government and the GBPA on the governance of Freeport. And it is hoped that any outstanding issues can be resolved between the parties in a sensible way. That's what we would hope. If not, we go back to the arbitration tribunal. There is still work to do in the arbitration, matters that still require determination and clarity. However, the government is pleased with the results of the partial award. I want to thank our hardworking legal team. I want to thank the Prime Minister for being the first leader in the history to seek justice for the Bahamian taxpayer and to challenge and seek clarity on the important principles of the Hawkesbill Creek Agreement. There's one thing I know. It's one thing I know. The Prime Minister has confirmed his deserved reputation as a brave leader and fighter for the people of the Bahamas. This process demonstrates it, and the results of the arbitration demonstrate it. So what will we have for you? We won't have a short one-page statement that mischaracterizes the arbitration proceedings. We won't give just the last page of the arbitration award. We will post on the Prime Minister's website a press release that describes what we interpret the award to be. We will put on the website the entire award, all 139 pages, for all to see and read. Again, we have the no objection from the tribunal to do so. And we will put on the award what I call a roadmap, but it's a guide to the decision, where if you have a question about a particular matter that I've discussed today, a ruling within that award that is interest to you, and you want to know what did the tribunal actually say, not what the GBPA said, and not what Ryan said, but what did the tribunal say? That guide will likewise be on the Office of the Prime Minister's website, so you can properly navigate your way through a rather long 139-page decision with a lot of legalese. So we do that for you in the full interest of transparency. We're pleased with the award. We thank the arbitrators for their hard work, and we thank them for more hard work to come. And I'm here to answer any questions that the press may have. Thank you.
We're clear, the government went into this seeking this outstanding money. You said you owed, I think it was over $300 million. You didn't get that decision you wanted in this, but you're saying you got more.
Well, the tribunal did not decide on a matter of quantum in this partial award. What they did decide on was that liability does in fact exist, and that liability that does in fact exist under paragraph 3 of the 94 agreement but it is almost identical in scope to what we could expect under 15D. They did say that. If you ask me what my opinion is that our claim and the full amount of our claim still stands. It still stands. And we will look forward to a review with the Grand Bahama Port Authority of the parameters of what they owe the taxpayers of the Commonwealth of the Bahamas. And if they are unable to come to an agreement with the government on a rational basis of determining what those expenses are, we will ask the arbitration tribunal to undertake that. Mm-hmm.
Partial decision. Can you break that down for me?
Well,
I heard
yeah.
what you said, but I want you to break it down.
So it's partial on 2 or 3 different areas, right? One, what did it do? It established that there is liability of the Grand Bahama Port Authority to reimburse the government of the Bahamas and the taxpayers of the Bahamas for administrative expenses incurred in Freeport by the government. It ruled that that liability absolutely exists. The second thing this arbitration award actually did was it clearly defined the roles of the government and the Port Authority with respect to the governance of Freeport. Those two are absolute in this award. What is to come is if we can't agree with the Port Authority on a mechanism of how do you calculate those expenses, they will decide that. That's the first thing. What else will they decide that they haven't decided upon? What is the applicability of those damages historically rather than prospectively? That hasn't been decided in this award. And that will be something that the tribunal takes up and decides as well. So there are some open issues for the tribunal to address, and that's why it's a partial award. But the partial award deals with the 2 major issues. Is there liability by the GBPA to reimburse the government? The answer is yes. And the second question that it clearly answers is what is the framework of governance of the port area? And does the GBPA have the exclusive right to govern the port area? That answer is no, that the government has a right to legislate, regulate, and participate in the governance of the port area.
And I want to ask you this, right? Because I know people are going to say you're trying to spin this.
That's why we're giving you the entire award.
I
instead of
know,
one page.
but people are going to say you're trying to spin this. The government went into this seeking $357 million. You didn't get it. What's your response to that?
That the arbitration tribunal did not rule on the award, quantum of the award. What they asked the parties is to adopt a different category that imposed the liability, and that requirement, paragraph 3 of the 1994 agreement, requires the parties to have a review. So they were unable to issue an award amount because the provision that they ruled is applicable requires the parties to have a review. If the parties cannot agree on that review, they are ready and willing to rule on the amount of damages owed to the government for the reimbursement of expenses.
How confident are you that you can get to that place when the GBPA is outright saying it was rejected, the government's claim is rejected? Do you feel that you can?
Well, we will give a good faith effort for the GBPA to come to the table. If they decide that they are not willing to come to the table or be rational in their approach, we will just go back to the tribunal, that's all.
Are you
Wait,
able to
how
say
much is this
costing?
entire process costing us?
I don't know today, I don't know today.
And what is the
But it's not cheap, I mean, I grant you that, it's not a cheap process. It's a 2-year arbitration, right? So,
what is the way forward from here?
but costs are still outstanding, I would say. That's another thing that was not ruled on, is the costs to the parties. The costs are still outstanding.
What is the way forward from here for the government? Are you planning to change or abandon your mission of changing the status quo in Grand Bahama?
Well, it is changing. I mean, you have seen the billions of dollars investments are going forward, all of those that were instigated by policy decisions of the Prime Minister and his cabinet. You've seen that MSC is going to put almost $500 million into the port to create a cruise destination. That was instigated by the government and its policy decisions to bring investors to Grand Bahama and to Freeport. So we are working tirelessly to ensure that Freeport has, one, the investment, the infrastructure that is required to succeed for the people of Grand Bahama. So nothing has changed. In fact, this only emboldens us to be more aggressive.
What's the likelihood of this being resolved before the election?
Well, I'm not sure when the election is. There's only 1 minute.
Good
Good try. Needless to say, the arbitration panel did say they are ready and willing to address the outstanding issues post-haste. My impression of the panel is that they would like to dispose of all outstanding issues on a very timely basis. And so we are preparing our submissions back to the tribunal. And we would expect them that they would want to address all outstanding issues in a rather expedited fashion. But I can't tell you if it's going to be before election because I'm not sure when election is.
AG, you mentioned a legal battle between IRCA and GBP.
Long-standing matter in the courts.
Can you clarify some of the details about that for us?
Well, so the power company effectively said, IRCA, because the Electricity Act that was passed was very specific in that it applied to all areas of the Bahamas, inclusive of the port area. The power company and the Port Authority, but this is a matter between the power company and IRCA, took the position that no, the regulation of utilities in Freeport is under the exclusive domain of the Port Authority, and that the Electricity Act should not apply to utilities within the port area because of the Hawksbill Creek Agreement. It's a long-standing matter in our courts. I'm glad this arbitration panel made it very clear that the government of the Bahamas does have the right to be able to legislate a regulatory framework in Freeport to regulate all utilities, inclusive of power, inclusive of telecommunications, and any other utilities.
Was the government's opposition of the GBP see another form of resistance to that?
No, no. That is for the betterment of the Bahamian people, especially those that are serviced by the power company.
And when it's all said and done, do you think this whole process was truly worth it for the government?
Absolutely. This is a, in my opinion, this is a monumental win for the government of the Bahamas. This is a historic event on the interpretation of Freeport and the interrelations between the GBPA, the Hawksbill Creek Agreement, and the government of the Bahamas, something that has been being debated in the public domain, and I'll let my colleague, Minister for Grand Bahama, speak a little bit more on that, but debated in the public domain for more than 50 years. This is a fantastic result, we think, but in any event, we are glad that there is a definitive basis for the interrelationships between the government and the Grand Bahama Port Authority as far as the management and governance of Freeport goes.
Giving the government more management and oversight pertaining to certain activities in Freeport.
Absolutely, and it has taken away the argument that the GBPA makes that the government cannot do it because of the Hawksbill Creek Agreement. It's a very clear determination. And to your benefit, Latrey, is it on the website yet?
Yeah, right.
It's on the website. To your benefit, you'll be able to download the guide to the decision and compare it to actually what the tribunal said. I don't know why the GBPA didn't feel it worthwhile to issue the entire ruling to the public. I do know why, but it's a shame they didn't, because they were given authority by the tribunal this morning to release the entire award, which they refused to do so. The government of the Bahamas can be fully transparent in this manner, and you're going to have every opportunity to see how the tribunal ruled on these very important points of law. Any more questions? I'd like to invite my colleague just for some immediate response to the ruling. Certainly the Minister for Grand Bahama, who's doing a stellar job. Ginger Moxie, please come up. Give him some comments. Thank you so much.
Thank you. Good morning. Today is an especially grand day for Grand Bahama. The government of the Bahamas is the government of the Bahamas, even in the city of Freeport, the port area. Finally, it has been resolved that the government has a binding say in the administration, management, and regulation in the city of Freeport. The administration of the port area is not fully vested in the Grand Bahama Port Authority. And this is the first time that any administration has challenged GBPA in this manner for the benefit of the people of Grand Bahama. So I would like to say thank you to our Prime Minister, the Honorable Philip Edward Brave Davis, Casey, and our Attorney General, the Honorable Ryan Pinder, Casey, and the Office of the Attorney General. Our Prime Minister, of course, will make a full communication tomorrow in the House of Assembly on this matter. And again, this is a historical landmark judgment for the benefit of the people of not just the city of Freeport, but for the people of Grand Bahama Island in general. Today is really a grand day. One that so many have looked forward to for such a long time. And again, the first time an administration has taken it on and wanted the government to have more involvement in what goes on in the city of Freeport. And today, that has come full circle. So again, my hat's off to our Prime Minister for taking it on and our Attorney General for seeing it through. Thank you.
Minister, just a quick question.
Yes.
You really hopped on this process benefiting the Bahamian people. Can you just expand on that? Many would argue that the city of Freeport and the other areas of Grand Bahama are starkly different. When you look at infrastructure, roads, things of that nature, how does this really benefit Grand Bahamians?
It benefits Grand Bahamians because the government is actually for the people. The government is the voice of the people. And when you have, a private entity that is controlled by families, there's not necessarily the vested interests of the people. So, of course, there's always general elections, and the people determine who they want to be their representations. And if you look at GBPA, there's one thing that was always said is that, there's these various parties. There's PLP, F&M, whatever else. And that there's one called GBPA, and it's never voted for. And so GBPA is able to do, as they wish in terms of administration, in terms of regulation, and in terms of management of the city, but, they couldn't be voted out. And so I think this today it's really a grand day for the people of Grand Bahama Island because they get to have more say in what happens in the management of the city of Freeport, which is a 230 square mile area where licensing, for example, is so much more than outside of the port area in the east and west of the island. I give you Celebration Key, for example. That used to be it was envisioned that would be in East Grand Bahama proper, which is would be controlled by the government of the Bahamas. So license fees for those applying would have been perhaps, say, small businesses, $100 or so. But once that was moved into the port area, you now have license fees that are extraordinary. And I think that's one of the issues there. The government of the Bahamas is for the people of the Bahamas, and it's not a private entity running a city. How often do you hear of private entities operating a city? So it's, of course, it's an act of parliament from 1955, and there's been various amendments along the way. But this is the first time that it's been challenged in a way that gives the government of the Bahamas more say in what's going on in the city of Freeport. So again, it's a glorious day for the people of Grand Bahama Island. Thank you.
So we're following for Pioneers from doing any work in the constituency at all?
Well, there's been some roadblocks along the way in trying to achieve certain things as simple as, of course, I'm dealing with the bazaar issue and trying to clean up that. And, there's been some issues with the other, owners of the bazaar and fees that were owed. And so there's been some things along the way that has stopped progress. But I believe in moving forward, we'll be able to get a lot more done. Thank you.
Good morning, and thanks to everyone for the coming. First of all, I want to thank the Attorney General and the Prime Minister of the Commonwealth of the Bahamas for the vision to pursue this arbitration, and I'm very pleased with the outcome. But just a historic walk down memory lane. In the 2012 Christie administration, we formed the Ministry of Grand Bahama. And at that particular time, I led the charge to establish the ministry and begin the proceedings by way of the Hawksbill Creek Review Committee. That committee laid the foundation for us to determine exactly what is going on in Freeport. And this administration went further with the arbitration proceedings. And we are pleased to have the outcome that we have today. The reason why that's important is because the Progressive Liberal Party knew a long time ago that the way how the Hawksbill Creek Agreement was being administered, there were many legal issues that we felt were necessary to challenge. And today, those landmark decisions brought us to where we are with the arbitration ruling, where for the first time from the establishment of the Hawksbill Creek Agreement, the government is now taking its truthful place to be a part of the decision-making process in the Grand Bahama area, and more specifically in Freeport. This is a huge win for the residents of Grand Bahama, who for a long time have been subjected to these harsh rulings, and despite the fact that the government goes through legislative transformation, it was always this issue of whether or not they could be applied in the Freeport area. This arbitration ruling clearly indicate that we have a say in the running of the city of Freeport, and that will mean major changes for the better for the residents of Grand Bahama.
Dr. Garbo, what are some of the changes that you hope to see happen, in the future in Freeport?
Well, when we established the Ministry for Grand Bahama, we always knew deep down inside that we will be working very closely, side by side, with the Grand Bahama Port Authority to run that city. I believe the ruling that we have today clearly indicate that the true purpose of the Ministry for Grand Bahama is for the government presence to be in Grand Bahama to ensure that the residents of Freeport, and by extension Grand Bahama, benefit to the maximum for what Grand Bahama has to offer. I believe this has opened the country, and by way of Freeport, to even further direct foreign investment for the Hawksbill Creek Agreement, as well as for the free trade zone to reach its true potential. And I'm so pleased, particularly with utilities, because I was the minister when the power company challenged the ruling with IRCA. It was a sad day for us, but sadness began, but now there's joy in the morning. And this particular arbitration clearly indicate that IRCA has a rightful place in the running of utilities in Grand Bahama, and that will bring tremendous change and growth and development for the island itself.
Any regrets about how publicly this entire situation has played out?
Well, for a long time, the Grand Bahama Port Authority was indicating that the Bahamas government was interfering with the operation of the Hawkesbury Creek Agreement. This arbitration clearly indicates that we always had a legal right. And sometimes it is best to do these things together, but sometimes you need legal proceedings to clarify this particular agreement that was established many, many years before many of us were born. And I think it has brought Grand Bahama into the 21st century and answered many of the questions that was over the head of the residents and the licensees. This arbitration has brought clarity for the way forward for the island of Grand Bahama, and that will mean further growth and development, not stagnation.
Do you think the government and the port can work together in Grand Bahama, given all that's happening, given the rhetoric and how heated it has become?
Well, I mean, from the arbitration findings, it is clear that both parties should go at the table. The government is prepared to do so. I believe the Grand Bahama Port Authority will eventually do so. It's better to come to the table to resolve this. But the rulings is clear. If they do not come to the table, then the second portion of the arbitration will begin. I believe it's best for us to sit at the table together and try to find a way forward for Grand Bahama in view of the fact of what the findings are today.
Thank you very much, Attorney General Pinder, for that very detailed explanation of the partial arbitration. Thanks also to Minister Ginger Moxie and Minister Michael Darville. Now again, this has been a statement on the arbitration process. It's been ongoing concerning the city of Freeport. For those of you who want to go through it with a fine-tooth comb, the statement is available as well as the ruling on opm.gov.bs. You can also hear today's commentary if you want to take a listen to it. You can find that on the Office of the Prime Minister's Facebook page. Thank you again, everyone. Have a good afternoon.